Good morning, friends. Though matter is pertaining to civil suit, but criminal side practitioner would definitely uh, know about this because clients may approach you claiming that the landlord is attempting to evict him without any process of law, by engaging elements or by force. Then you cannot avoid that client. At least there is an opportunity to step into the civil side practice also. A simple suit you can file before the civil court that the tenant should not be evicted except under due process of law. That single cause of action suit was earlier filed in multi numbers. This is what, but in that field, I have a case which should be read by the aspirant candidates for judicial officers because this facts and the question of law definitely be possibility of uh, listing in the question paper. Therefore, I would like to share this for the betterment of civil lawyers, aspiring civil lawyers as well as criminal lawyers also. This is AR 2025 Bombay 105. AR 2025 Bombay 105 Bombay Nagpur bench Ganesh Vinayak Mudaliar versus Anil Kumar Jagannath Pancholi. The problem was the Pancholi was a tenant when there was a possibility of his being evicted illegally. He filed a suit before the civil court restraining the landlord from evicting. Thereafter, landlord filed an application for eviction under Small Causes Act before the Small Causes Court, and they are seeking a payment of rent, so many things. But thereafter, he filed an application under Section 24 CPC, which is transfer petition. That transfer petition was dismissed. The transfer petition was filed to transfer the civil suit pending before the civil court to the small cause court. But the district court dismissed the Section 24 application, stating that small cause court have no jurisdiction to entertain the civil suit. Therefore, that was the questions referred to the Bombay High Court. The Bombay High Court judges very intelligently discussed the provisions of Small Causes Court, Section 26 and 19(1) of Small Causes Act. See, the Bombay High Court also relied Manukshal Dhanraj Jain versus Eknath Vittal Gokhale, 1995 SC 1102. They say section, they have read the section 41, notwithstanding anything contained elsewhere in this act. They say, therefore, they say the suit relating to recovery of possession between licensee and even for an injunction can only be instituted in the small cause court in accordance with the section 41 of the act. That was the ratio. Therefore, they have categorically held that the section 41(1) does not apply where suits and proceedings for recovery of possession of immovable property. The difference between the words used was relating to recovery of possession on one hand and terminology for recovery of possession of any immovable property. So, relating to recovery of possession was deeply discussed and held that the small cause court can still entertain suit for injunction between landlord and tenant, and transfer was ordered. I hope you understand. It is too difficult for understanding, but it must be understood because there is possibility of filing transfer petitions and you may be there too. Slowly you can learn lot of things. Best wishes.